right, gentlemen, you're ready to proceed?
Good afternoon, may it please the court. If I could make an introduction before we start. I'm Charles Wyrick of Ortel Kelly Law Firm, a member of the Tennessee Bar. Arguing for the plaintiff appellant will be Thomas Joyce of the Pennsylvania and New Jersey bars. He's been duly admitted pro hoc vice, and he's argued before this court. I'll now turn it over to him.
Thank you.
Good afternoon. I would like to reserve 3 minutes for rebuttal.
All right, sir. You may proceed.
Thank you. Your Honor, Judge Stafford, I recall you were presiding over the Willie Adams appeal that I argued last September. So I do recall that case. I believe Judge Armstrong was on that as well. But for purpose of this case, Your Honor, there's a couple different things. This is an FELA case, and the issue is Judge Weiss in Shelby County excluded the plaintiff's expert witnesses, the liability expert, Dr. Hernando Perez, and the medical causation expert, Dr. Ernest Chioda. This is obviously an abuse of discretion appeal, and so this is the definition I have for an abuse of discretion. An abuse of discretion occurs where the trial court has applied an incorrect legal standard or where its decision is illogical or unreasoned and causes an injustice to the complaining party. That's the Tennessee Appellate Court case, Specialty Com IOM Services versus MedSerant Holdings. What's important here is a couple things that are not at issue. And there was no dispute about the qualifications of either Dr. Perez or Dr. Chioda. The defense indicated at the argument, and the court in its ruling, oral ruling, indicated that as well. In fact, there's not even a dispute as to the methodology. In the ruling that Judge Weiss came down with after the hearing, basically says, while unusual, the court doesn't have a problem with the methodology per se. So methodology is typically the big challenge in these cases, whether or not the experts can give these types of opinions. What's really happening here in this particular appeal is that the problem that the lower court, the trial court, had with the experts was that when we discussed the articles that they rely upon, the court didn't believe that the article stood for the proposition of what Dr. Perez said or what Dr. Chioda said. For example, in the one case, there was two, by the way, there are two things going on here, diesel and asbestos. I'm going to focus today just on asbestos, okay, to make it a little bit simpler. The point, though, is that, first of all, experts are allowed to extrapolate data from articles or epidemiological studies to begin with. That's what they do. They exercise their professional judgment. But let's be consistent with what Judge Weiss did in this case. What he's saying is that the conclusions don't jibe with what the data is or what the studies are that they claim are their support. The reality is this is, as to asbestos, a couple different things. One is, we know that underlying this, one of the challenges, and it's actually in the judge's ruling, it's also in the order prepared by defense counsel, claiming that Dr. Perez, the industrial hygienist, who's our liability expert, does not in any way identify the level of exposure to asbestos. Annie Dowdy's job title at the Burlington Northern Santa Fe was clerk, but she was also a janitor and a porter. And that period of time from 1980 until 1992, she regularly went down in the basement of the tower facility and swept up whatever's down there. BNSF was cited by OSHA in 1991 for asbestos in that basement. Asbestos pipe insulation that was in friable condition, meaning it's in deteriorating condition. We actually have a document that proves it. That's often difficult for a plaintiff to prove the actual exposure, but we have an OSHA citation that gives us this asbestos exposure, and we have Dr. Perez opining that if Mrs. Dowdy swept those floors up, including that asbestos dust, for 15 minutes in a day, that is a violation of the OSHA permissible exposure limit. Not the time-weighted average over your career, but over what's called the short-term exposure limit. So the evidence in this record, it's actually in the hearing itself, in the April 19, 2021 hearing, the defense is arguing there's nowhere does Dr. Perez find some sort of exposure above a permissible exposure limit. That's not correct. If the court were looking at the actual record, there's clearly an OSHA violation. An OSHA violation under FELA is negligence, okay? Secondly, the other thing that's important in the context of the asbestos case is this, is Judge Weiss was questioning whether or not whether or not the article supported this connection that asbestos causes kidney cancer. We actually have an article. It's not just a single article. It's the Smith article, and it's actually a meta-analysis, which is important because a meta-analysis is something that reviews a bunch of different epidemiological studies. And the actual conclusion in Smith, which is the article that Dr. Chioda relies upon for his opinion that in general causation, asbestos is capable of causing kidney cancer, this is the conclusion that the Smith article or meta-analysis has. It is concluded that asbestos should be regarded as a probable cause of human kidney cancer. The name of the article itself is Asbestos and Kidney Cancer. The evidence supports a causal association. So if Judge Weiss he quibbled with the diesel exhaust articles because they didn't come out and say causation. They said, one said there's an association, or there's a greater association between gasoline and kidney cancer than diesel exhaust and kidney cancer. But the reality is, okay, let's take that for what it's worth. The judge should be consistent and hold it be, at least if the article itself that our expert, Dr. Chio, relies upon for general causation, supports actual causation, and that's what this article does, because it's reviewing a whole bunch of different articles, this is sufficient. So when the judge says that in the actual, this is the actual ruling, where is it? Court doesn't have a problem with the methodology per se, but the court does have issues with their conclusions in that the studies they chose to rely upon do not support their whole conclusion. That is incorrect. That study, Smith, in and of itself, supports the conclusion that asbestos causes kidney cancer. So the court is willing to cite to the conclusions of the diesel exhaust articles because they're a little weaker than the asbestos in that they're only showing an association. But in the article that actually gives us definitive causation on asbestos, it's ignored. And in fact, the defense counsel in their argument actually goes out of their way to argue that it doesn't say that. And this is from the hearing itself in front of Judge Weiss. This is defense counsel on the Smith article I just brought up. It was a preliminary study, so you have to look at that preliminary study, which did not say we find a causal connection or even an association, but it says it's a probable human kidney cancer. Probable human kidney cancer, that's what she says, okay? I actually bring that back up when I'm arguing to the judge, and this is what I say about the Smith article. It basically says exactly what I just read to you, that asbestos is a probable human carcinogen for kidney, okay? The other thing that's important here is in the opinion, and obviously this is, the actual order itself is written by defense counsel. You know, I want the court to realize that the order that's actually written by defense counsel and signed by Judge Weiss contradicts the actual ruling and the actual hearing. But what's important is the actual ruling incorporates, or the order incorporates both the hearing and the judge's oral ruling from the bench. We had our hearing on April 19th, 2021, and on April 26th, the court brought us back and announced this ruling in open court. But the point, what's important about it, though, is this is the actual order that's signed that we filed our appeal to. This says, Dr. Perez has not pointed to data or literature supporting his conclusion that plaintiff was exposed to elevated levels of asbestos. That's completely an error. Dr. Perez has admitted that he cannot say that Mrs. Dowdy ever had an exposure over 0.2 fibers per cc. Again, Dr. Perez testified in his report, in his deposition, that she was overexposed above an O'Chappelle. That is a level that proves negligence under FELA. This is another part, this is the last part of the order that's taken from this oral ruling and the hearing, and what it says is the court finds the studies and data plaintiff's expert chose to rely upon do not support their ultimate opinions that plaintiff was unreasonably exposed to levels of diesel exhaust and/or asbestos, or that diesel exhaust and/or asbestos are capable of causing plaintiff's renal cancer with regard to general causation or specific causation. My point is that's the court's order. The court's order is not consistent with the record. And I know there's case law out there in Tennessee that says that, you know, the order that's prepared by the winning party, if you will, in this case the railroad, should be consistent with the judge's oral ruling from the bench and the hearing at the actual oral argument of the motion to exclude the experts. My point here is that's exactly what this is. This is an abuse of discretion. The one thing I want to point out, just to clarify why it's in the record with Dr. Perez with regard to this elevated exposure, what he says in particular, because I asked him this question in his deposition, I also reiterate to the court in the argument is, I asked Dr. Perez in his deposition, and this is about the sweeping asbestos debris in the basement. So if you're sweeping and you do that, then it is completely reasonable to assume that there will be exposures at that level for a short period. I'm talking about a PEL, so my question is this. So if Annie Dowdy was actually tasked with sweeping the floor of the basement that had asbestos debris for more than 15 minutes, would she be exposed above the STEL, S-T-E-L, which is short-term exposure limit for OSHA? Answer, yes. We have evidence in this case that she's overexposed above a PEL, yet the court is saying we have not proved anything on the record about elevated exposure levels. The court is, I don't know, putting blinders on or whatever, but the bottom line is if the court simply reads the record, just simply the hearing from April 19th and the ruling, and then compares that with the actual order prepared by defense counsel, this is clearly an abuse of discretion. The plaintiff, I'm not necessarily agreeing with the trial court in terms of how they did their analysis, because as I said in the beginning, typically methodology is the primary focus, but if we're going to hold Judge Weiss to his reasoning and his analysis as to how he found a way to throw the diesel exhaust case out, then he ought to be consistent, and the asbestos case, if nothing else, should be sent back to the trial court for a jury trial.
So the OSHA violation of 91, did that say anything at all about the levels of asbestos in the basement?
Here's what the OSHA violation said. This is dated, I think it's July of 1991. And Mrs. Dowdy worked in that basement job from 1980 to 1992. So she did it for 11 years before OSHA came in and said there's asbestos in that basement. Here's what it says. The thermal pipe insulation in the basement of the art office was generally in good state of repair, with the exception of the air handling unit close closet off the hallway. The thermal insulation and mud and pipe wrapping material was in poor condition and was also found in the debris on the floor under the air units. The thermal pipe insulation is friable and presents a potential health risk when damaged. This material should be cleaned up by a licensed abatement. It goes on to say, it does not give us fibers per cc, and the asbestos PEL changes with time. For example, the permissible exposure limit from 1976 to 1986 was 2
But I'm
fibers.
assuming somewhere in that violation it says this is asbestos.
There's no doubt that the OSHA citation confirms that the insulation in the basement is asbestos, clearly. Your question, though, Your Honor, as to whether or not the citation specifically identifies a particular exposure limit, it does not. But there's no dispute that she was working in the location where OSHA cited BNSF.
And I know you focused most of your argument on asbestos here, but I have to say, I do find this diesel exhaust very curious. I don't know how Dr. Perez comes up with an exposure level to diesel exhaust. Can you explain that?
Absolutely. So what industrial hygienists do, both the railroad industrial hygienists and the plaintiff's industrial hygienists, they use what's called a retrospective exposure assessment. That's a generally accepted methodology for industrial hygienists. What that is when you don't have data. For example, there's technology out there where Annie Dowdy could have worn a monitor her entire career. It existed way before she started in 1980, and they could have known exactly what she was exposed to with regard to diesel exhaust. However, there is nothing like that. Therefore, we must go to what an IH or an industrial hygienist does is they go to the literature and they compare the exposures in the peer-reviewed literature to the exposures reported by, in this case, Mrs. Dowdy, and they compare them. And candidly, Dr. Perez, when you look at she had a number of different jobs over her 33-year career. She worked from 1980 to 2013. And there's only certain times where he puts her at a higher exposure. And one example of a high exposure to diesel exhaust is from 1996 to 1998, she worked as a janitor in the diesel shop. And in the diesel shop at Tennessee Yard, they ran the locomotives inside. There is peer-reviewed literature that says that if you're running locomotives inside an enclosed environment, it is well above this threshold limit value. Threshold limit value is similar to permissible exposure limit, but it's adopted by the American Conference for Governmental and Industrial Hygienists as opposed to OSHA. The point is, the way we prove the diesel case is, all he has to do is Dr. Perez takes a look at that scenario where she's talking about cleaning when these locomotives are running in an enclosed environment, and he compares that to a study called Model and Postenbach, which is cited in his report. And we know that there's elevated levels of diesel exhaust elemental carbon above 20. 20 micrograms per cubic meter is the threshold limit value that was proposed by the ACGH but not adopted. There is no PEL for diesel exhaust. The closest thing we have is this 20 micrograms per cubic meter, but the way we prove that in FELA cases is the railroads have adopted that TLV as an industry standard, and when they violate their industry standard, that is negligence under the FELA. So for example, if she was exposed above 20, the study Model and Possenbach says it's 40, it's 60, it's 80 at times inside there. We can prove that that's an overexposure to diesel exhaust as well. The problem the trial judge had with Dr. Perez and his analogy to Pronk was he doesn't use Pronk for the conclusions because the conclusions are generated from studies. It's like a meta-analysis also that are generated by candidly self-serving railroad IH reports that basically downplay the levels. The point, though, is the purpose of Pronk is for him to develop the framework to determine the exposures, and he uses that for that reason. I tried to explain that, and basically what Judge Weiss told me was that the Pronk opinion, the conclusion from Pronk doesn't jive with what Dr. Perez is saying. You know, and the other thing I think, Ron, I'll finish up with this,
No,
is...
You have finished.
Oh, okay, I'm done, all right. Thank you.
Good afternoon, Your Honor.
Good afternoon.
I'm ready, Your Honor.
Go right ahead.
Your Honor, I'm George Lewis of the Memphis Bar, and our firm is privileged to represent the appellee in this case. Counsel said at the beginning of his argument, and I tried to listen carefully, that he was not going to address diesel exhaust, but unless he's withdrawing it from the case, I'm just telling you I'm happy to answer questions about both substances. I want to also make sure we're clear. Ms. Dowdy's work history is not really disputed, but she was on and off at BNSF with a couple of stints off, which are not material here. I also want to be sure everybody's clear that in the order, and as I read the transcript, the plaintiff in this case has a difficult burden because they would have to get a reversal as to both experts and both substances in order to obtain a reversal of the summary judgment. And that's stated in the transcript and stated in the court's order. I've heard a lot of impressive, sophisticated discussion about studies. But what I'd like to begin with stressing to the court is all of the many problems that Judge Weiss found with these two experts. It's as many as I've seen, and I got my 40-year pen 14 days ago. In paragraph 10, he points out that these experts came to their conclusions prior to performing any studies in this area. So they are strictly, on retainer. They're not out there studying it. They haven't published anything separately. That's paragraph 10 of the order. Paragraph 11, Dr. Sciotto relied upon the Peters study and the Layden study. The Peters study says, diesel exhaust alone does not appear to increase the likelihood of kidney cancer. This was a study, may it please the court, that was studying gasoline and diesel fuel together, and then they rotated out and studied just the diesel fuel, and so diesel exhaust, and so that was one of the points of the study, and the study
Well, what about, I appreciate you feel like you need to argue both, but let's, just so we can keep it straight here, let's start with asbestos though. So
Sure.
we've got this 91 OSHA violation, friable material covering the ducts, and plaintiff is able to say, well, as a janitor, I had to go down in that basement and sweep up whatever was on the floor. And it had to be some asbestos. I mean, obviously that stuff gets all over the place once you use it. Why isn't that enough to get them over the threshold of some asbestos exposure?
Let's talk then about Perez first as it applies to asbestos, Your Honor. The asbestos here, may it please the court, is around a pipe like it usually is in the basement. That's not where she usually works. And so when he was asked at his deposition about that, Perez admitted that actual testing in the basement area where the asbestos was found revealed a sampling level of asbestos that did not exceed permissible exposure limits. That's R3, page 323-325. He admitted that he didn't know a lot of characteristics about this space where it was discovered. That's page 326 and 327. As a result, Perez did not know whether the plaintiff worked in close proximity to the thermal pipe that was involved. Those are the same page citations. Perez admitted that there was no evidence that plaintiff was exposed to asbestos in excess of OSHA's permissible exposure. That's volume 3, page 328-329. And that he had based these citations on this 91 study, this citation, but the citation itself did not find limits above permissible limits in 91. Perez stated that although he didn't know, he thought the plaintiff spent less than 5 minutes a week in the basement where the asbestos was found. He admitted that the primary responsibility, or most of her activities, were related to the paperwork on the first floor, not on the basement. That's page 319 of the same volume. He admitted that there was some third-party testing done and that asbestos in the basement, quote, were low, volume 3, page 323. And testing performed by OSHA, BNSF, and a third party all established asbestos levels below exposure limits. That's R volume 3, page 324. With respect to Scioto and asbestos, Your Honor, and there are more. There are lots of these. There are lots of these problems, in my view. That's why, in my view, the appeal has no merit. But as Dr. Scioto didn't identify any study, I think he pronounced it Scioto. Dr. Scioto did not identify any study which found that asbestos causes kidney cancer. Instead, he relied upon 2 studies which found that merely an association between asbestos exposure and kidney cancer.
And so what about the Smith paper that was cited in the appellant's argument? Asbestos and kidney cancer, does that not?
And I made notes and I looked to see if I could find exactly what he was talking about during his argument, Your Honor, and I couldn't find exactly that. But I would say this to the court. If I cite 5 things to you and 3 of them don't make sense to you and they're unreliable, it is not an abuse of discretion to exclude that expert. It might not even be an abuse of discretion if he messes up one issue bad enough. So I would say to Your Honor that this is a multifactorial analysis under McDaniel to which clearly an abuse of discretion applies, and for good reason. I've been down to Chancery Court where these motions were argued in front of members of this court, and Judge Weiss has probably done hundreds of these motions in his day, and he's got factor after factor after factor. Would you like to talk about diesel exhaust a little bit before we? Okay. If you don't want me to, if you just want to stay on asbestos, that's what I'll do.
Well, the appellant seems most interested in asbestos, and
Okay.
so that's what I most wanted to hear about.
Okay. Well, I have more problems with Perez, if you'd like to hear more about that. He admitted that he had no interaction with the delaminating thermal pipe that was the source of the asbestos. In other words, he hadn't inspected it or studied it. That's volume 3, page 326. And he admitted that he didn't know a lot on the characteristics of the space in which the asbestos was discovered. As a result, he didn't know whether the plaintiff worked in close proximity to the thermal pipe referenced in the OSHA citation that was the source of the asbestos. That's 326, 327. And ultimately, he was unable to determine the level of plaintiff's alleged exposure to asbestos. That's page 328. And on page 329, he admits that there is no evidence that the plaintiff was exposed to asbestos in excess of OSHA's permissible exposure. Think about all those facts for a moment, and then think about an appellate court saying that a trial judge that relied upon all of those facts in excluding the expert abused his discretion. If we mean it, if we really mean we're going to affirm unless the trial judge abuses his discretion, think how this opinion would stand if we've got 19 problems with one expert and a dozen problems with another expert, and we still say that Judge Bob Weiss abused his discretion. I don't believe the court wants to go there. I don't think it's best for Tennessee jurisprudence. And I don't think it carries out that extra sentence that we have in the rule that requires the trial judge, if he finds that the opinions are unreliable, he doesn't really have any discretion not to exclude it. It says he shall exclude it if he finds that it's unreliable. And in this case, we have many, 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 many reasons why it's not reliable. And I just wanted to make sure, because it's not in the table of contents in our brief, at R586, there's this Chapman opinion from a court out of state, and it holds exactly as did Bob Weiss as to
Is that the
Dr. Schiavo.
Nebraska?
Yes, sir. It's Kootenai County, Idaho.
Yeah, or Idaho, yeah.
Idaho. Any other questions, Your Honor? Anything else? Thank you.
Thank you.
Briefly, Chapman was in Idaho, and it was not exactly on point. I argued the case in front of the judge out there with the same defense attorney, Camille Reifers, and Chapman was only a diesel case. There was no asbestos case.
Do you agree with the proposition it's an all-or-nothing situation here? If you don't get both experts?
Absolutely not.
Okay.
The point is, we could get to a jury with just the asbestos claim, and that's what I'm doing here. I'm arguing the stronger evidence. The weaker evidence is the diesel. Not to say that other judges don't put it in. I just tried a case in Chicago 2 weeks ago. We got a $2.2 million verdict on a diesel asbestos case with Dr. Perez. The point here is, though, that we only need to prove one. I'm pointing out the stronger parts of the plaintiff's case.
Well, I'm not asking about either asbestos or diesel exhaust, but rather, do you need both expert witnesses here? I mean, suppose we agree with Judge
Absolutely.
Weiss that says, you know, Dr. Perez seems awful weak here, just throwing what appears to be micrograms out of thin air, and why should we rely on an expert like that? And you have to go with Chioda. I mean, does he get you where you need on
No.
causation?
Under FELA, we need a liability expert, industrial hygienist like Dr. Perez, and we also need a medical causation expert.
So you do need both,
We
okay.
need both, but we don't need both exposures is the point, though.
Yeah.
This is, McDaniels, what I heard Mr. Lewis say a couple things about was, he's pointing to parts of the deposition where Ms. Reifers asked the questions of Dr. Perez. I read to you the question I asked Dr. Perez about a violation of the OSHA STEL. There are points, and there's two different PELs for OSHA. The permissible exposure limit that he's referring
Yeah,
to
but,
is,
I mean, what I keep circling back around to is, though, where was the OSHA STEL violation? I mean, you point to the 91 citation, but that not a STEL violation. That's that's what you read it was. I mean, so where do we get that? Where do we get that violation?
they don't measure PELs when they're doing an OSHA. No, they're determining whether asbestos exists, and that clearly showed us asbestos dust from pipe insulation in the basement.
I
where
mean,
this-
you would agree, OSHA does say that there's some level of asbestos that, we sort of naturally occurring, we all live with. I mean, it's not all, I mean, it may kill us all eventually, but it may not all cause cancer, so there's got to be some minimal level.
Absolutely.
Yeah.
There's a certain amount in the air we breathe right here in Jackson. There's a certain amount of diesel exhaust, a certain amount of asbestos, a certain amount of benzene. The point is, the railroad's not on the hook for exposing people to background levels like you and I walking the streets. Where liability implicates under the FELA is if it's above background, it implicates liability. If it's above a permissible exposure limit, that's negligence. The reason why when they test and they come back in the railroad and it says that we didn't test any high numbers, because they're testing it, the air, they're doing what we call a bulk sample. They're not testing it when the woman is sweeping and it's becoming friable. Dr. Perez describes it as a cloud of dust. If they tested when that happened, it's going to be well above the PEL. Getting back to that PEL, there are two types. One is 8 hours a day, 5 days a week, 52 weeks a year over a 30-year work life expectancy. That's the traditional TWA for OSHA permissible exposure limits. That is different than the short-term limit, which is a 15-minute high exposure, which is where Dr. Perez gives us that. He concedes, what Mr. Lewis said, that he can't say that over her whole career she did that because she spent a lot of time as a clerk. But for 12 years, she's in that basement sweeping. 11 years into it, they finally tell her she's sweeping this asbestos up. The point here is, what I read McDaniel's the case, obviously, it's the roadmap. What I read McDaniel to say is that when the experts have conflicting opinions, that's for the jury, that's for cross-examination, that's not for the judge to throw the baby out with the bathwater here. All I'm asking you to hold the Judge Weiss to is be consistent. If you're going to use those articles to tell us that it must say that there's causation, we had an article in the record that specifically says that as to asbestos, and we have absolute proof of asbestos exposure. Thank you, Your Honors.
Thank you, gentlemen. We will take this matter under advisement and attempt to render an opinion at the earliest possible time. We appreciate your argument and the discussion. Ms. Angie, anything we need to take up before we recess?
No, Your Honor.